All right. Friday, President Trump testified under oath. Medical records. Attorney General Pam Bondi had. Documents. The judge not happy. According to court transcripts released yesterday, sworn testimony contradicts medical evidence filed 3 weeks earlier. I've been going through the 147-page filing. Here's what I found. Trump's legal team submitted health documentation stating he couldn't attend a deposition, called it a scheduling conflict based on doctor's orders. Bondi's office had different records. Same doctor, different conclusions. Friday's hearing, Judge Michael Harrison didn't hold back the transcripts public. I pulled the sections. Let me show you what happened in that Miami courtroom. Quick context. Donald Trump, sitting, president, facing a civil deposition related to financial disclosures from his 2024 campaign. The issue whether presidential medical exemptions apply to ongoing civil litigation from actions before taking office. Timeline fast. Version. Early June, Trump's attorneys file a motion to delay deposition site medical documentation. 2 weeks later, Bondi's DOJ division surfaces contradictory records from the same physician. Friday, emergency hearing in the Southern District of Florida. Judge demands answers. That's the setup. Now, the documents. The case itself stems from allegations involving campaign finance reporting during the 2024 election cycle. Not criminal, civil, but sworn testimony required. Trump's team argued presidential duties plus health concerns made appearance impossible. Standard legal maneuver happens in high-profile cases. What made this different? The paperwork didn't match. Attorney General Bondi, formerly Trump's pick, now operating independently under DOJ protocols, had access to medical records through official channels. What she found raised questions the judge wanted answered under oath. Friday morning. Okay, the evidence. First document filed Friday. I pulled page 73. The transcript states, quoting, "Here, Mr. President, your submitted medical evaluation dated June 4th claims you were physically unable to attend proceedings, yet hospital logs show you played golf that same afternoon for 4 hours. That's not my take. That's Judge Harrison. What it means. Testimony conflicts with documented activity. But here's what got me. Page 89, different section. Bondi's team presented cellular location data, not classified, subpoenaed from Secret Service movement. Logs, public record for presidential whereabouts. June 4th, day of claimed incapacity. Trump's location tracked to Trump National Bureau, 1:47 p.m. to 5:52 p.m. 4 hours, 5 minutes golfing. Medical note from Dr. Richard Castellano said complete rest advised. No strenuous activity recommended for 72 hours. Put those together. Yeah, problem. I went through this 3 times. Patterns. Clear. Medical exemption filed June 5th. Supporting documentation dated June 4th. Activity logs contradict both dates. All documented. Now, what nobody's covering. Exhibit M in Bondi's response filing. Page 104. A second medical opinion. Same doctor, different letterhead. Dr. Castellano apparently provided 2 assessments. First, submitted by Trump's attorneys, emphasized rest and limitations. Second, obtained through DOJ medical. Record request cleared Trump for, quote, normal daily activities, including moderate physical recreation. Same physician, same week, opposite. Conclusions. Read that again. That changes this. The judge specifically asked, Dr. Castellano, you authored both documents. Physician response, page 112. I provided medical information as requested by different counsel offices. Both statements reflect accurate assessments based on information available at each consultation time. Translation, doctor gave answers, matching what each side asked for. Fallout, Judge Harrison ordered complete medical discovery, every record from January 2026 forward. Scheduled Trump for in-person testimony, no exemptions. Set contempt hearing parameters if non-compliance occurs within 48 hours of Friday's session. The legal standard here matters. Presidential immunity doesn't typically Extend to civil matters from before. Taking office. Established president. What's unusual? Sitting president giving. Sworn deposition during term. Hasn't. Happened since Clinton in 1998. Different circumstances, but same legal framework. Trump's defense argued. Executive privilege. Judge rejected it. The alleged conduct predates. Inauguration. That distinction matters. Bond's position stated clearly in page 34 of her filing. No American, regardless of current office, stands above legal accountability for actions taken as a private citizen. Strong language, especially given her previous role as Trump's attorney and political ally. The medical angle adds complexity. Presidential physicians typically provide wide latitude. Health privacy. Protections are substantial. But when medical claims become legal strategy, when health documentation gets submitted as evidence, it becomes discoverable. That's what happened here. Trump's team made it evidence. Bond's team exercised discovery rights. Judge enforced standards. Standard procedure just rarely involves a sitting president. That's just the first document. Subscribe. I'm not done. The medical records are one piece. What came out about the financial disclosures? That's next, and it's detailed. Okay, but look, gotta be fair here. The other side has a point. Few points. Actually, Trump's legal team says this. Is prosecutorial overreach targeting a sitting president during active duty? And honestly, some of it holds up. Their argument. Presidential responsibilities genuinely do create scheduling, conflicts, national security briefings, diplomatic obligations, crisis response. These aren't negotiable. Medical privacy deserves protection. Forcing disclosure of health records sets concerning precedent for future presidents, regardless of party. Constitutional law. Professor Emeritus at Georgetown, Martin Letterman, put it this way. Compelling. Presidential medical testimony during active term raises separation of powers. Questions courts have historically avoided. Don't agree with all of it, but that's not nothing what they've got legitimate. Executive function concerns about time. Demands precedent showing presidential. Legal protections during office even. Former Obama look. I'm not here to tell you who's right. Bond's interpretation. Evidence supports it. Civil matters from before office traditionally proceed. Trump's interpretation. Evidence there. 2. Presidential duties. Create legitimate constraints. Both can be true. That's what makes this complicated. The medical record specifically. That's where Trump's defenders make their strongest case. Health privacy matters. HIPAA exists for reasons. Presidential. Medical information has national security implications. What if adversarial nations gain detailed health data on the sitting president? That's not theoretical. That's real concern. Trump's personal attorney, Alina Habba, argued exactly this in her Friday. These proceedings. Health information becomes weaponizable. Fair point. The counterargument. Trump's administration attorney, Carl Thompson, admits the timing creates complications that wouldn't exist for private citizens. Response. Forcing medical discovery creates intelligence vulnerabilities. Our adversaries watch these proceedings. Health information becomes weaponizable. Fair point. The counterargument. Trump's team made medical claims first. You can't use health as legal shield, then claim privacy when challenged. That's Bondi's position. Legally sound. But Trump supporters see political motivation. Bondi served in Trump's previous administration. Now she's prosecuting. They call it betrayal. Conservative legal analyst Jonathan Turley framed it. When your own appointed attorney general pursues you this aggressively, it raises questions about institutional loyalty versus legal duty. That resonates with Trump's base. The deep state narrative fits here. And you know what? I get it. If you supported Trump, put him in office, watched him, appoint Bondi, then she turns around. With this level of legal pressure feels personal. The golf course evidence particularly bothers his defenders. Secret Service, logs getting subpoenaed, presidential, movements tracked for civil litigation, sets precedent they hate. Next, Democratic president faces Republican attorney general, same tools available. Now, what I can tell you what the documents They show medical documentation. Inconsistencies that Judge Harrison found credible enough to order full discovery and in-person testimony. Whether that's justice or overreach, that's interpretation. The facts are the facts. What they mean, that's where people split. This didn't come out of nowhere. Backstory quick. 3 months ago, initial civil complaint filed by Campaign Finance Watchdog Group alleged discrepancy in reported versus actual expenditures during 2024 campaign. Standard opposition research stuff. Happens every cycle. 6 weeks ago, discovery phase begins. Trump's team files multiple delay motions. Some granted, some denied. 4 weeks ago, deposition scheduled. Trump's attorneys request postponement. Medical grounds. Someone even said on record, former Federal Elections Commission attorney, out of noti, these delay tactics are textbook. Nothing unusual about the strategy. What happened? Bondi's office pushed harder than expected. Pattern. Delay motion filed. Medical documentation submitted. DOJ challenges. Veracity. Every time. Previously courts granted. Extensions. Presidential deference. Until Friday. What changed? The contradictory medical evidence became too obvious. Judge Harrison has reputation for patience with presidential cases. He gave latitude, multiple extensions already granted, but the golf course logs cross a line. You can't claim medical incapacity while documented doing recreational athletics the same day. Doesn't work for regular defendants. Doesn't work for presidents. That's where judicial patience ended. The broader context. Trump's facing multiple legal challenges simultaneously. Criminal cases in different jurisdictions, civil suits, congressional investigations. His legal strategy across all of them. Delay, run out clocks. Hope for political changes. Bank on presidential immunity. Worked before not working. Friday. See where this is going? Like this. The medical evidence is damning. But what Judge Harrison said during the actual hearing, that's the part that went viral. Stay with me. Friday, 10:47 a.m. Here's what happened. Trump's attorney began standard executive privilege argument. Judge Harrison interrupted 90 seconds in. Counsel, I've read your briefs. I've reviewed the evidence. I've given extraordinary difference to presidential scheduling. But when medical claims become demonstrably false, we have a problem. Room went silent. What followed? Harrison directly addressed Trump on video feed, ordered medical records production within 72 hours, scheduled in-person deposition for July 8th. No exceptions. 11 minutes. That fast. Now, what everyone missed, while people focused on the medical contradiction, something else happened. Bondi's team introduced financial records. Campaign expenditure logs from October 2024, previously undisclosed. Judge Harrison admitted them as supplementary evidence. Didn't rule on substance, but allowed them into discovery record. Trump's attorneys objected. Too late. Already entered. Harrison's response. Your client's credibility is at issue. Scope of discovery expands accordingly. Wasn't reactive. Calculated. You can see it in how Bondi's team structured the filing. Medical contradictions first. Gets attention. Gets judge frustrated. Then financial documents slipped in while defense is scrambling. Standard prosecutorial tactics. Build credibility. Damage. Expand scope. This is where it gets interesting. Those financial records reference payments to medical consultants during the campaign. $340,000. Total across 4 months. Same doctor who provided the contradictory assessments received $73,000 in quote consulting fees from Trump campaign entities between August and November 2024. Not illegal. Campaigns pay medical consultants regularly, but it creates appearance issues when that same doctor provides favorable medical exemptions. Later, Bondi highlighted this in her oral arguments, page 89 of the transcript. Your Honor, financial relationships between defendant and medical providers offering litigation. Exemptions deserve scrutiny. Judge agreed. Expanded discovery to include all financial relationships with Dr. Castellano. Trump's team never saw it coming. They prepared for medical. Privacy arguments got financial. Disclosure instead. Don't go anywhere. What I show next changes the picture. The financial trail connects to something bigger. Something involving campaign finance structures nobody's talked about yet. What are experts saying? Former Assistant U.S. Attorney for Southern District of New York, Jennifer Rogers. 11 years. Prosecuting white-collar cases. When medical providers receive substantial payment from defendants, then provide favorable testimony. Judges notice. Discovery expansion is inevitable. Plain English. The money trail killed Trump's medical defense. Another one. Constitutional law professor at Harvard, Lawrence Tribe. Presidential immunity for pre-off conduct remains one of our democracy's crucial pressure points. This case tested directly. Key there. This establishes precedent. Future presidents watching closely. Here's what's interesting. Even Trump-appointed former DOJ official Gene Hamilton admits the medical documentation inconsistencies created. Problem standard executive privilege. Arguments couldn't overcome. When both sides agree, pay attention. What's actually unusual here? Not the legal principles. Those are established. It's the political optics. Bond. Prosecuting Trump. Former federal prosecutor Renadu Mariotti breaks it down. Attorney General independence from presidential influence is exactly what institutional design requires. Bonds. Following proper protocol. But is she, though? Former Trump White House counsel Pat Cipollone offers different view. There's aggressive prosecution. Then there's targeting. The speed and scope here raise questions about motivation. See the split? Legal analysts on institutional norms. This is proper. Political analysts on optics. This looks targeted. Consensus. Medical evidence. Contradictions are legally significant. Presidential immunity for pre-off. Conduct remains unsettled. Financial. Relationships with medical providers. Warrant discovery. That's where professionals land. Nobody's saying the medical contradictions don't matter. They clearly do. Question is whether the legal response is proportional or political. Former independent counsel Ken Starr, who investigated Clinton, said deposing sitting president should be absolute, last resort. But when evidence, contradictions are the stark, courts have limited options. That framing helps. Last resort, but necessary given circumstances. Whether you think it's justice or persecution probably depends on whether you voted for Trump. The law itself pretty clear on this specific question. Useful. Break down like it. This is complicated stuff. The legal framework versus political reality. They're not the same thing. More nuance ahead. Why should you care? Real talk. How this affects actual people. Money. If you've ever wondered whether presidents face same legal standards as regular citizens, pay attention. This case answers it. Numbers. Presidents get more. Procedural difference, but not immunity. From pre-off civil cases, your wallet precedent set here applies to future political figures at every level. Governor in your state commits fraud before taking office. This case determines whether they can delay. Accountability indefinitely using executive privilege. What some people doing. State level. Politicians watching closely. Legal. Strategies being rewritten based on how. This concludes. Not advice, just what I'm seeing in legal filings across multiple jurisdictions. Precedent. This sets a precedent. Next, time you hear a politician claim they're too busy governing to face legal accountability. Rules change. Quick example, you elect a mayor, later find out they committed contract fraud before taking office. They claim mayoral duties prevent depositions. Before this case, probably works. Courts defer to executive function. After this case, medical and documentary evidence better align perfectly or judges won't buy it. Not dramatic. That's how this works. Now, who's affected right now? Every sitting elected official with pending legal issues watching this. Political. Defense attorneys already adjusting. Strategies. Medical exemption claims. Just got way harder. Hits within weeks. As other cases cite this precedent. congressional members with pending depositions, governors facing civil suits, state attorneys general dealing with pre-off allegations. Trump's not unique in having legal issues while governing. He's unique in having them as president, but the legal framework applies down ballot. What nobody wants. To say uncomfortable part, if you think president should focus on governing without legal distraction, this case makes your life harder. If you think no, one's above the law regardless of office, this case validates your position. Not trying to scare you. That's what documents suggest. Both positions have merit. Both create real consequences. Presidential distraction during crisis because of civil litigation. That's a legitimate national security concern. Presidential immunity from accountability. That's a legitimate democracy concern. Pick your priority. The legal system's forcing that choice. Practical. What inform people doing? Reading actual court documents, not just headlines. Understanding difference between criminal and civil standards. Asking their own attorneys about how precedent affects state-level cases. If you're in business, politics, or any position where pre-employment conduct might create future liability, this matters. Question to ask your attorney. How does presidential civil case precedent affect executive privilege? Claims at other government levels? Knowledge helps. This isn't about Trump. Specifically, it's about whether executive function creates legal immunity. Courts saying no with caveats and exceptions, but fundamentally no. That's a shift. Recent shift. Implications spread wide. How'd Trump respond? Made it worse. Honestly, posted on Truth Social within 2 hours of Friday's hearing. Called it another witch hunt from a disloyal former ally. Specifically targeted Bondi. Said she betrayed the administration for deep state approval. Quote, Pam Bondi was a nobody before I elevated her. Now, she joins the swamp. Sad. Reaction post got 2.3 million engagements within 12 hours. Hashtag Bondi. Betrays Trump trended for 8 hours. His base mobilized. Death threats against Bondi increased enough that DOJ provided additional security. Not hyperbole. Official DOJ statement. Confirmed enhanced protective measures. Bondi came back. I serve the Constitution and rule of law, not any individual. My oath demands impartial justice, professional, direct. Then her office filed motion for sanctions against Trump for attempting to intimidate prosecutors through public statements. That motion's pending, hearing scheduled for Thursday. Then latest development. 3. Republican senators issued statement supporting Bondi's independence. Romney, Moski, Collins, not cooling down, heating up. Trump's legal team filed emergency appeal to 11th Circuit seeking stay on deposition order. Long shot. Medical contradictions are too documented, but they're trying. Congressional Republican split. MAGA caucus demanding Bondi's resignation. Traditional conservatives supporting prosecutorial independence. Party fracture in real time. Fox News even split. Prime time defended Trump. Morning shows question the medical evidence. What's still unclear? 1. Whether 11th Circuit grants stay on deposition order. 2. What the financial records actually show beyond the medical consultant payments. 3. If Trump will actually appear for July 8 deposition or force contempt proceedings. Coming 11th Circuit has emergency hearing scheduled Thursday, July 2nd on the stay motion. Trump reportedly meeting with new legal counsel, considering team changes. Bondi's office preparing contempt motion in case of non-compliance draft already filed under seal. Congressional oversight committees announcing investigation into DOJ independence. Both parties different focuses. Date to watch July 8th. Either Trump appears for deposition first, sitting president to do so since Clinton, or he refuses and faces contempt. No middle ground left. Judge Harrison made that clear. Deposition happens in person on schedule or marshals get involved. Never happened to a sitting president. Marshals enforcing contempt against the chief executive. Constitutional crisis territory. Also watching Dr. Castellano. He's been subpoenaed for Wednesday, July 1st. Deposition about the contradictory medical assessments. What he says under Oath could determine whether this is medical privacy dispute or fraud. Should know more by then. Medical expert. Testimony tends to clarify or destroy. Cases. No in between. Subscribe. I'll cover the update when it drops. Thursday's appellate hearing. Wednesdays. Doctor deposition. July 8th deadline. This is moving fast. I'll break down each development where we are right now. Judge Harrison's deposition order stands July 8th in person. No exceptions. Trump's emergency appeal pending before 11th Circuit. Bondi's office's contempt motion preparative needed. Dr. Castellano scheduled for Wednesday. Deposition enhanced security for AG Bondi due to threats. Congressional investigations announced by both parties scheduled. Wednesday, July 1st, Dr. Castellano deposition. Thursday, July 2nd, 11th Circuit. Emergency hearing on stay. Friday, July 3rd, deadline for Trump's financial disclosure production. Monday, July 6th, Judge Harrison status conference. Tuesday, July 8th, Trump scheduled deposition. Not public yet. What specific questions Bondi's team plans for the deposition? Those remain confidential until the session. Also, sealed complete financial records connecting Trump campaign to DR. Castellano, partial disclosure only. Clock's running. Every day Trump doesn't comply, contempt risk increases. Every day that passes, political pressure intensifies. Republican primary. Challengers already using this in campaign messaging. Leadership distracted by legal problems. Democratic opposition calling it accountability. Independent voters polling shows they're split based on whether they believe the medical contradictions were intentional. This isn't theoretical anymore. Real consequences coming within days. That's where we are. Trump facing mandatory deposition in 8 days or contempt. Proceedings. Surface read. Medical lie got caught. Judge responded. Case proceeds. But watch what happens with DR. Castellano's Wednesday testimony. If he confirms the contradictions were requested by Trump's legal team, this becomes potential fraud. If he claims miscommunication or administrative error, Trump's team has defense. Single deposition might determine whether this is procedural, dispute, or criminal referral. Also, watching how 11th Circuit rules. Thursday, those 3 judges, 1 Trump appointee, 2 Obama appointees have massive latitude. They could stay. Everything pending appeal. Could uphold Harrison entirely. Could split the difference with modified timeline. Presidential power versus judicial authority. Classic separation of powers. Question. I'll be watching the actual rulings, not the cable news reactions. Story's not over. Still developing. Subscribe for full picture. Not just headlines. When documents drop, I'll break them down. When testimony happens, I'll pull the transcripts. This case sets precedent that'll matter for decades. Regardless of your politics, understanding the actual legal framework beats reacting to outrage. Toxin.